Welcome to a guide on the Real Estate Agents Authority 101. This video will outline the 6 key milestones of a standard sale process of a fee simple property. Discussing this topic today are my fellow students, Richard, Frank, Will, and myself, Henry. Key legislation. Before we get into the details, we must first acknowledge the key regulation entities in real estate. The purpose of the Real Estate Agents Act 2008 is to promote and protect the interest of consumers in respect of transactions that relate to real estate and to promote public confidence in the performance of real estate agency work. The Act achieves this by regulating agent, branch managers, and salesperson, raising industry standards, and providing accountability through disciplinary actions. Types of contracts. It is important to consider the 3 different types of contracts relative to the sale and purchase of real estate. These include sale by negotiation, sale by auction, and sale by tender. The different types of contract affects the method of which offers can be made. The contract variations involve different processes throughout the 6 key milestones in a standard sale process of property.
The 6 key milestones for a real estate agent in a sale process for a fee simple property are 1. Engaging with the vendor client, 2. Taking the vendor's property to market, 3. Receiving offers from potential purchasers, 4. Entry into an agreement for a sale and purchase with a selected purchaser, 5. Payment of a deposit, and 6. Settlement of a sale of a property. Number 1. Engaging a vendor client. Upon engaging with a client as an agent, you must provide an agency agreement and the approved guidelines. This ensures that all the details, rights, and responsibilities of your relationship are agreed upon and understood by both parties. It is also your duty to suggest they get legal advice before entering into this agency agreement with you. A standard agency agreement should include the following: commission details and a desired sale price, how much can the agent spend for marketing and what avenue is this money coming from, the duration of authority by the agent, sole or general agency, how the property is going to be sold, for example, auction or negotiation, details regarding open homes, do statements made by the agent need to be approved by the principal, what is actually for sale regarding details, addresses and chattels, etc. Number 2. Taking the vendor's property to market. Under Section 10.9 of the REAA 2012, it states that a licensee must not advertise any land or business on terms that are different from those authorized by the client.
Number 3. Receiving offers from potential purchasers. The offer process varies dependent on the relevant contract. With sale by negotiation, a prospective purchaser must communicate their offer through completion of the commercial terms in sale and purchase agreement and upon execution with the agreement. With sale by auction, potential purchaser will receive all auction terms and conditions prior to the event. The auction will commence with the auctioneer inviting the first bid. Bidders can revoke their bid at any time until acceptance. With sale by tender, prospective purchaser will prepare and submit confidential written offers to the agent to be considered by the vendor. The prospective purchaser will be provided the specific terms of the tender prior to the offer. Number 4. Entry into an agreement for sale and purchase with a selected purchaser. Section 9.7 of the REAA states that before a prospective client, existing client, or customer signs an agency agreement, a sale and purchase agreement, or other contractual document, a licensee must recommend that the person seek legal advice, ensure that the person is aware that they can seek other advice and information, allow that person a reasonable opportunity to obtain the advice. Number 5. Payment of a deposit. Under the ADLS Sale and Purchase Agreement, there is no specific requirement for a deposit to be paid or the amount payable. However, in New Zealand, it is customary for 10% of the purchase price to be paid as a deposit. A deposit has 2 legal functions. Number 1. Part payment of the purchase price. Number 2. A deposit is also an earnest. In the event of a cancellation, the deposit is forfeited and the vendor will retain it. Additionally, Clause 2.1 states that a deposit is payable immediately upon execution of the sale and purchase agreement. Number 6. Settlement of a sale of a property. Clause 3 of the ADLS Sale and Purchase Agreement outlines the possession and settlement details. Final inspection. The prospective purchaser has the right to inspect a property prior to settlement. This will generally be undertaken 1 to 3 days prior to settlement. Conveyance and undertakings. The settlement will be undertaken using the electronic transfer system for the title and solicitor's undertakings. Requisition clause. The purchaser has a specific time period to investigate the relative vendor's title. Generally, this is a 10-day period that commences from the date of the agreement.
In the course of acting as a real estate agent, you should always be aware that your actions should not mislead or result in misconduct of the above requirements and regulations of the profession. Let's take a look back at some real-life examples here in New Zealand over the last year of where a real estate licensee was found liable for misconduct and unsatisfactory conduct. These examples will serve as an example of what not to do when engaging in the sales of real estate and the harsh consequences you can face by neglecting to comply with the correct code of conduct. Not to mention the damaged reputation that could serve as a long-term burden for an agent in such a small market like Auckland. This first case was brought by the Real Estate Agents Disciplinary Tribunal against real estate agent Andrew Smith for unsatisfactory conduct. This claim was held by the tribunal as he knew his obligations to his clients of obtaining an agency agreement prior to the marketing of a commercial property and failed to fulfill them. Subsequently, Mr. Rankin was neither fined or faced with any penalties. Instead, the court decided to impose an order requiring the licensee to undergo training or education under Section 93D, indicating that rehabilitation is a function of professional disciplinary process under the Act.
The second case was brought by the Real Estate Agent Disciplinary Tribunal against Benjamin Dwan, who was a licensed agent. The allegations were surrounding the licensee's failure to disclose important information about his relationship with the property manager. This case has presented a conflict of interest regarding potential defects with the property. The tribunal found Mr. Dwan guilty in engaging in unsatisfactory conduct, and he was further censured and ordered to pay a fine of $2,000. We hope you enjoyed our presentation on the key regulatory requirements for a real estate agent and the 6 key milestones in a standard sale process of a fee simple property. If you want to be ahead of the property game and have to not worry about your next big commission, make sure you hit the like and subscribe button for updated real estate tips and tricks in the near future.